and welcome to a newsflash episode of Unpacking the Case, the podcast by David Jones Bold, the real estate law specialists. As always, I'm joined by our head of legal training, Richard Snape. Hi, Richard.
Hello, Lizzie, and how have you been since I last saw you?
I am not too bad, thank you, for a very long January, but we're coming to the end of it. But before we do get to the end of January, we want to talk about one of the webinars we've done, the first of the year for our wider sector audience on the 8th of January. And it was all about the Landlord Tenant Act 1954, grounds of opposition, renewal terms and compensation. We had a lot of questions. It was our biggest attendance of a webinar to date, so understandably we couldn't get through everything. So let's rattle through some of them now.
Okay, fire away.
Thank you very much. The first of which is, if a tenant is opposing a Section 25 notice on ground F or G, what is the timetable for them to make an application to court? Is it the end of the Section 25 notice, or is there a fixed timetable?
Yeah, it's not something I discussed in the course itself. I mean, time doesn't permit all these things. If it's a Section 25 notice, it's going to be for between 6 and 12 months notice, terminating no earlier than the end of the fixed term of the tenancy. Any time during the duration of the 6 to 12 month Section 25 notice, the tenant can apply to court. If they don't apply to court within that time period, the duration, then unless the landlord and the tenant have agreed an extension of the time before the end of the Section 25 notice, then the tenant's basically lost. So they've got to make a decision by the end of the Section 25 notice, unless the landlord's prepared, if he wants to negotiate along to do so, to have an extension.
Thank you. Next question. Underground G, what constitutes occupation?
It's when the cases say it's a question of fact, really. I mean, like companies, you don't have to be physically present yourself. You might be present through managing agents or employees and the likes and still be in occupation. But it is a question of fact and degree. And there was a case we mentioned called Kensington and Chelsea, London Borough Council in Melcraft, where they wanted to use ground G, did the council, the landlords. It was a commercial premises with a flat above it and came within the 54 Act, and they wanted to use ground G because they wanted to temporarily house homeless people in this premises on Portobello Road, pending a decision as to whether they can have permanent housing or not. And amongst other things, they decided that it's not the landlord who's going to be in occupation, it's the homeless people, so they couldn't use ground G. I thought that was quite controversial, actually. I can remember another case in 2002, it must have been, Court of Appeal case called Ambrose and Kaye, which again I didn't mention in the course, where if it's a company, basically you've got to have a majority of the shares in that company, the controlling interest really in the shares. And the landlord wanted to use ground G and occupy through the company. The company was jointly owned with his wife. But what they did during the actual court hearings, during the recess, is the wife transferred her share capital to the husband, and it was held that they could use ground G, by the time of the decision. They had a controlling interest, but it is a question of degree.
Next question was, speaking of longer leases, can you provide an update on the abolition of upwards-only rent reviews under the proposed English Devolution and Community Empowerment Bill?
Yeah, it's still on the cards. It's gone to the House of Commons at the end of October last year, and it's in the House of Lords waiting, last I heard, and this is the end of January, for committee stage. It's not expected to come into force, they say, until 2027 to 28. I mean, the one thing that can make, well, there are several things that were changed in the House of Commons, and one being that you have to come within the definition of the 54 Act. You occupy under a lease, at least partly for business purposes, to come within the ban of upward-only rent reviews. They've dropped the requirement for occupation because if you've got a sublease, the subtenant is almost certainly the one in occupation. So suddenly the subtenant would have a upward and downward rent review, and the head tenant wouldn't, which would be a disaster. And they've also allowed options to renew. They'll trigger the things as well as options to put the upward and downward rent review post it coming into force. So that's the latest.
Thank you very much.
My pleasure.
Do you have to have planning permission for change of use to occupy for another purpose underground G?
No, you don't have to actually have planning permission. You have to have, I mean, there's the test is, have you got a real chance, a real possibility? Cunliffe and Goodman from 1951, which actually wasn't a 54 Act case, and most people seem to think it is, about Section 18 of the 27 Landlord and Tenant Act and dilapidations claims. But it's got to be out of the zone of contemplation and into the valley of decision. Those were the days when people spoke like that. A real chance, a real prospect. There was a case back in the 1960s, 1963, Gregson and Cyril Lord Carpets, that said that for the first time. And there's been quite a lot of cases since. Would a person or business take the risk? I mean, there was a case, Gatwick Parking Services and Sargent, which basically said that a real chance, a real prospect. And there was a case I remember about the same time in the late 1990s called Coppin and Bruce Smith, where they'd already failed in their planning applications and the likes. As a tennis courts, and they'd failed on the grounds that we needed sort of sporting facilities in the locality. They changed things slightly and made another application. They didn't have a real chance, so they failed. But you certainly don't have to have planning permission.
Thank you. Another question here. What if the term of the original lease exceeds 15 years?
Yeah, if you go to court, then it's Section 33. They can't award more than a 15-year lease, which sort of reflects 5-year rent reviews, basically. 3 times 5 being 15. That doesn't mean to say you can't just decide between the two of you for a different duration lease, and you can certainly do that. It's just in the event of a dispute, the maximum duration of 15 years.
Thank you. Next question. What if a landlord could demonstrate grounds F or G but subsequently changes their mind?
Well, there's nothing wrong again with them just deciding, to not, sort of go through the due process and negotiate for a new lease outside the 54 Landlord and Tenant Act. But, sort of just give a new lease and not oppose, basically. I can't see anything wrong with that.
Thank you. And somebody asking, can you comment on SDLT on renewal and lack of renewal? Some tenants tend to stay on without renewing the lease.
Yeah, stamp duty, land tax, and also land transaction tax in Wales is, the thresholds are different, but in this area it's pretty much the same. You pay SDLT on the net present rental value on the grant of the lease. And the net present rental value, to the extent it exceeds £150,000 for commercial properties. And there's a convenient formula that does that for you. I prefer the Revenue's website myself. If you were to hold over after the end of the fixed term of the tenancy, if you hold over for 1 day, it's deemed to be a 1-year linked lease. So if you had a 10-year lease, you pay SDLT on the land transaction tax based on net present value on the rent for 10 years. Then it's deemed to be an 11-year lease, and say you hold over further, and then it becomes a 12, 13, 14-year lease, and so on. And you're supposed to fill in another land transaction return at the end of the year. Like all things SDLT, it's quite complicated. But that's the basic idea. I've come across sort of people in residential assured and assured short-hold, whilst they still exist, tenancies. They should have SDLT bills, especially if they've been holding over for a period of time. Quite bizarrely.
Okie dokie, thank you. A question here about one of the cases you mentioned in the session. Would OMA be applicable when considering a 54 Act lease to Electronic Communications Code 2017 agreement?
Yeah, OMA is probably certainly one of the 2 most important 54 Act cases of all. It basically says, it's about Section 35 of the Act, and how do you decide terms, resides, property, rent and duration? Well, you're supposed to have regard to the terms of the current tenancy, and OMA, the House of Lords, said that means that the starting point is the old lease is the basis of the new lease, and it's got to be just and equitable between the parties to change the terms. And just because there's a change in the law, for instance, or you want to upgrade to modern standards, doesn't make it necessarily the case that the lease should be changed on the renewal. There has been a case on renewals in the 54 Act and the Electronic Communications Code. Communications equipment is a law unto itself, quite literally. But there's a case called Vodafone and Gresham Borough Council about a block of flats with a mobile phone mast, a high-rise block of flats with a Building Safety Act with a mobile phone mast on the roof. And the landlords, the council, wanted to change the terms on a renewal to reflect the fact that they have to have risk assessments and method statements in relation to safety on these premises. And to some extent, the court accepted that, or it was accepted. But they wanted to reduce the tenant's ability to upgrade the equipment and the likes, and they failed on that. So it does depend to some extent on its circumstances, but the starting point is the old lease is the basis of the new lease, and upgrading to modern standards is not an automatic. There are lots of cases which have said otherwise.
The next question is, does the landlord need to pay statutory compensation if the tenant agrees an early surrender at a surrender premium?
You're only entitled to compensation for disturbance on a non-fault ground, EF or G. If you occupied the premises, you get double compensation if you've occupied for 14 years before the lease came to an end for the purpose of the Act. You get a lot of institutional leases exclude compensation of a disturbance, but if you can show 5 years occupation before the lease came to an end for the purpose of the Act, then you lose that ability. So if you're not there, I'm not sure I've answered the question, but if you're not there for those time periods with a sort of bit of a discretion, a day or two, then you won't be entitled to statutory compensation.
The next question, is an intention to demolish enough, or do you have to have planning permission for what you intend to construct on site?
It's the same as ground G, which they're kind of very similar. You have to have at the date of the court hearing, that's Betty's Cafe and Phillips Furnishing Stores. You have to have a genuine intention to demolish, reconstruct, but it's got to be out of the zone of contemplation into the valley of decision, a real prospect or chance of getting planning permission, but not actual planning permission. So very similar to ground G.
Thank you. Next one. Is it tactically unwise for a landlord to use a number of grounds to oppose a new lease?
I wouldn't say so, because, especially if you're trying to use grounds E, F or G is pretty rare, but demolishing, reconstructing or G occupation for your own purposes, because you might have to pay compensation for disturbance, as we mentioned. And if you can slot in a ground where there's tenants at fault, like A, serious disrepair, or B, persistent delay in paying the rent, you might not have to pay the compensation. I don't think it's a bad idea at all.
Thank you. Can a local authority use ground G to use the property for them providing social or temporary housing, or would they need ground F as significant works?
Well, that's that Kensington, Chelsea and Melcrafter case again, that it was held that you weren't intending to occupy yourself. It was the homeless people who were going to be the occupiers. And so you couldn't use ground G in those circumstances, although I've got my doubts about it. But that's what they said in that particular case. So the answer is no, you can't. You'd have to think about ground F. But if it's just a series of small bits of work you need on the premises, in the cases, there's a case called Barth and Pritchard, which said if it's none of them in their own right are sort of demolishing, reconstructing, therefore you couldn't use ground F. You're doing things like putting partitions up and a new boiler system, a new wiring. It'll have to be a bit more significant than that to be able to use ground F.
With the second limb in the Gulf agency case, it mentions change of use. However, what would be the case if the landlord wanted to use the property for the same use as the tenant?
Well, that's the Gulf agencies on Ahmed, where the landlord intended to use for their combined solicitors practice minicab business. I don't know if you've had a word about that possibilities yet.
It's definitely a good idea.
and anyway, they said, there's a two-stage process. You must have a genuine intention and you must have an ability to come to fruition. Again, a real chance, a real prospect. Yeah, the landlord doesn't need to. I mean, if he doesn't need planning permission, he doesn't need to get planning permission. And there are cases such as that NVL, the lead mill, if you remember that one, Lizzie, the lead mill
Yeah.
venue, which I have been to in Sheffield, because that's the kind of guy I am, where they successfully used ground G, even though they were running exactly the same business. And it's not the only case to say that. Tried to argue it was a breach of human rights, and they failed on that.
Okie dokie. Thank you. Next question. If a tenant has several units on an industrial site, all of which are on 3-year terms, can they apply to court for longer leases of, say, 6 or 9 years and be successful, even if the landlord opposes their renewal of all the leases?
Well, I mean, if the landlord fails in his opposition, I mean, the tenant's entitled, and if there's no agreement between the parties, up to a 15-year lease. There's a lot of exceptions to this, but if you look at some of the textbooks, the tenants usually get what they're asking for as long as they are asking for no more than 15 years or the duration of the original lease. That was the Court of Appeal decision, not the House of Lords decision, in Betty's Cafe and Phillips Furnishing Stores said that. So you're a bit at the whim of the court if needs be, but if the original lease was only 3 years, if the landlord objects, you might not be able to get longer than a 3-year lease, even if the landlord doesn't successfully oppose.
Why is ground D not used as much as other grounds for opposition?
I don't know, to tell you the truth. It's where you offer reasonably suitable alternative accommodation. I can't think of a reported case on it. And the answer is, I don't know. It seems quite a sensible thing to do especially if you've got sort of over occupation or something, the tenants don't need that particular size premises, you offer them a suitable alternative. But the answer is, I don't know.
Okay, thank you, Richard. Next question is about Section 36 of the Act. If there is a court order and the tenant asks for the court to revoke, can the landlord claim all of their costs?
Yeah, well, it's basically, if the tenant is not bound by the court's decision for a lease, if they don't like the terms, they can give 2 weeks' notice not to be bound. What the provision says is that in those circumstances, any order of costs will remain, but the courts can basically vary the order of costs. So they've got a discretion, if you like, to require the tenant to pay the landlord's costs in those circumstances.
Okay, thank you. Somebody asking, well, they're saying we're under a Section 25 notice with no court application and the landlord has inserted green lease clauses. Can we refuse?
Yeah, these green lease clauses are obviously getting very popular in leases. There's a couple of county court decisions which are not really precedents. One was the W.H. Smith's Commerce Real Investment Gazelle Shaft, if you remember that one, Lizzie. The
Yes,
W.H.
fondly.
Smith's in Shepherd's Bush and the whatever centre it's called. In that particular case, the landlord wanted to change the clauses whereby the tenant would be responsible to pay for a new EPC, and they would be responsible for carrying out an energy audit, and the landlord could charge the tenants and they'd be responsible for bringing it up to energy efficiency. Landlords tend to do it on the basis that, we'll all be happy because you'll get reduced energy bills, which is, if you've got a short 54 Act excluded lease or whatever. I'm not sure that's the case. But in that particular case, the court applied O'May and City of London Real Property Company. It wasn't in the original lease, so it shouldn't be in the new lease. And the fact that green lease clauses weren't used at the time of the original lease was an irrelevance. There was another case called Clipper Logistics, a county court case, and Scottish Equitable, which said the same thing. So on the face of it, on the basis of these couple of county court decisions, you could object. But I don't think we've heard the last of green lease clauses on lease renewals. And I think that's it, Lizzie.
Thank you very much, Richard. Thank you very much, Richard, and thank you to everybody for listening. We'll see you again in our next episode.